everyone, my name is Prerana Singh and I am a student of BA LLB first year at Aligarh Muslim University, Faculty of Law. My today's topic is a case named Indore Development Authority versus Manoharlal and others. The case is about the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Settlement Act 2013. Before this law was amended in 2013 and before it was named as Land Acquisition Act 1894. The case is about an issue regarding to the land acquisitions made by government for development project. This case was heard by a bench of 5 judges in Supreme Court. The conflict arises when a 3-judge bench delivered a verdict over the same act in a case named Indore Development Authority versus Shailendra in 2018, which was just opposite to a verdict delivered by another 3-judges bench in a case named Pune Municipal Corporation versus Harakchandra Misrimal Solanki in 2004. In Pune case, the court delivered that if the amount of land was not deposited in the bank account of landowners or in the court of jurisdiction and the amount was still in the treasury of the government, then it will not count as paid. But just opposite to that, in the Indore Development Authority versus Shailendra case, the court delivered that if a tender has been passed of the same amount, then it will count as delivered even if the owner hasn't received that amount or if he deny to receiving that amount because he is not satisfied with that. In both of the case, the amount will be considered as paid under the Article 31 of Land Acquisition Act and it will count as completion of. These two opposite judgments create a great chaos in mind of everyone that whether the amount will be counted as paid or not, and therefore the judgment came that a 3-judge bench cannot overrule a judgment made by another 3-judge bench, and therefore in 2019 a 5-judge bench has been made to hear the case and clear all the confusion. What are the issues of the case? The first issue of the case is whether the article used to clear all the confusion. Now, what are the issues of the case? The first issue is that word use or in Article 24 and Clause 2 of Land Acquisition Act, what it should be considered as it should be considered neither nor or either or. The condition of clause is that if the amount is not being paid by the government or by state to the landowner, or if the possession was not taken by the government, then the acquisition will lapse. So now the question arises was that if both of the conditions should be filled for the lapse of land acquisition or only one condition should be filled. So on this issue, the court delivered the decision that the or should be read as neither and nor, not either or. The second issue in the case was the word paid and deposited were used both in the same clause, and does the mean of both of these words is same or not, and what is the mode of payment or when will the payment will be considered as paid. So on this, the court said that if a tender has been issued by the government from his treasury for the payment of land, then it will considered as completion of his duty and will count on then the Land Acquisition Act will not lapse. And the second thing was that whether the word paid and deposited mean the same. On this, the court said that the word paid and deposited cannot mean the same. The third issue in the case was what is meant by physical possession and are the condition for physical possession of the land. On this, the court said that the government has to issue a memorandum, or you can say a panchnama, for the transfer of property on the name of government, and after doing that the government is the only or state is the only owner of that land. However, the court also said that the state does not need to forcefully push out those residents who are residing on that land, though those people can live on that land, but the state will remain the only owner. And in case if there is a need of that land, then the state can ask the resident to leave the land immediately. They will have no possession over the land. So this is all about case named Indore Development Authority versus Manoharlal and others, which was a issue in Land Acquisition Act, or we can say the Land Acquisition Act 2013, which was amended. Thank you for watching.